The Supreme Court just challenged private property rights in Richmond, BC. And now homeowners across the province are wondering what it means to them. In this video, we're going to break down exactly what happened, why it's important, and what it means to you if you own property in BC. I'm Sean Provincial. I'm a real estate expert who lives in Victoria, BC, and thank you for checking out the channel. We post videos every week to help you stay informed. So if you want to know the best strategies and you always want to be up to date on what's going on in our market, make sure that you like and subscribe. As always, if you have plans involving real estate, I'd love to chat about them as well. You can use the link in the description to get some time with me. Okay, now let's jump into this week's video. This has been going on for a really long time, like over a decade, 513 days in court, and the longest trial in Canadian history. The reason that so many people are talking about this right now is twofold. First of all, no one was notified about it. The case itself was between Cowichan tribes and Canada, but in the ruling, they decided that this is something that should set precedent for all land in Canada, not just Crown land. And so this is something that has come as a huge surprise to private landowners because there's some risk it could affect their title. Now, the backdrop is that the Cowichan tribe claimed Aboriginal title over a section of land on Lulu Island in Richmond. This was land that they'd used historically for hunting and fishing, and at some point Canada came in and placed title over it, essentially extinguishing their rights. And they said, well, that doesn't really feel right to us because we'd been using it for hundreds of years before you guys showed up. Now, in the ruling, the judge said that Aboriginal title absolutely should have a bearing on the use of the land and suggested that maybe Aboriginal title and freehold title or fee simple title, essentially private ownership, could coexist. Now, this works fine for Crown land because there's not someone who's spent years or decades paying down a mortgage, but in the precedent that they set, it could be applied to private landowners, and there's a number of private landowners in Richmond who are already affected by this. So this has a lot of people extremely concerned because it's a direct threat to their ability to freely use the property that they'd been told they were the sole owners of. Now, this is an issue that is bound to get contentious, and unfortunately, both sides have a really valid argument. On one hand, you have the Aboriginal claim to the land, essentially saying that it was unceded land. And you've probably been to an event where they did a land acknowledgement saying that they recognize that the land that they're on is unceded territory of a certain tribe. And there's a lot of this in BC. Somewhere between 90 and 99% of the land in BC was never ceded to Canada for us to be allowed to put new title on. So this is a issue that could have sweeping repercussions. On the other side of it, you have private landowners who have been paying down mortgages and just living as families trying to get by for decades, being told that, well, maybe they don't have the right to the land that they've invested so much of their livelihood to protect for their families. This is a situation where you look at both sides and really wish that you could find a compromise. Now, in the ruling, the judge said that perhaps freehold or fee simple title, where you have exclusive ownership of the land, could coexist with an Aboriginal title for use. And that might make sense in Crown land, where it's for public use in general, and perhaps they could take a greater stake in being allowed to carry out whatever it is that they feel they would want to with the land. But then on the other hand, this could be someone's backyard. This could be a commercial property where someone runs a business, and having that person be told that after all these decades in investment that they'd made, they wouldn't be able to enjoy the exclusive use of the land that they were told would be exclusively theirs is really scary. And frankly, those two claims to title can't really coexist. Freehold or fee simple title on a whole conceptually means exclusive use, not exclusive use combined with someone else's rights to the property. So there's a real mess, unfortunately, that's being made by the ruling of this court case that we don't really have all the answers to yet. One of the fascinating things about humans as a creature is that we seem to be consistently attracted to the same parts of this amazing planet. For centuries and millennia, people tend to gravitate back towards the same parts of the world or of a continent or an island. And so when we look at archaeological remains, a lot of the time they're in really nice neighborhoods where people, modern people, still want to live. Some of the best parts of Victoria are some of the parts that you have the highest likelihood of finding archaeological remains. I'm talking about Oak Bay, Fairfield, downtown. These places have a lot of history behind them. And so these issues aren't restricted to Richmond. In fact, there are similar lawsuits already underway in Kamloops and Kelowna. So we know that this is going to be not an isolated case, and it's something that will set precedent and lay the groundwork for future disputes to take place. Now, like I said earlier, when we look at the amount of BC that is unceded, it's a huge proportion of the land. Obviously, in order for them to claim Aboriginal title, they would have to have some burden of reasonable proof that they had historically used it consistently. And so it's not actually 99% of BC that would likely face a dispute like this, but we know that this is something that isn't isolated and will likely affect the province and Canada in a broader sense. In the ruling, the judge specifically said that this should set precedents. And so this is a problem for Canada, and it's something that we're going to have to work to find a resolution to. The issue is, it's been 10 years for us to get this far, and it's not resolved. There's a lot more work ahead of us. And so most people imagine that this will take at least 1 or 2 years to resolve. The major challenge is that during that time, the people who are immediately affected by this, the people in Richmond, the people in Kamloops and Kelowna who are facing these challenges, are going to be tied up. Now, Richmond involves a number of private landowners. Kamloops and Kelowna is more isolated to a dispute with some resort properties. But still, there's a lot of individuals who might have to put their life on the sidelines for a little bit while this gets sorted out. Think about it. Real estate is something that's supposed to be an asset that you can make liquid in a relatively short amount of time. If you have the majority of your family's wealth tied up in your home and you face a change in your life, maybe someone needs to be put into a care facility or faces an illness, or you just need to relocate for work or to get your kids into a better school, well, an issue like this affecting the title of your property is something that essentially makes your property illiquid. Think about it. Would you buy a home that you knew you might not be able to claim title to? Probably not. And even if you were to put an offer on a home like that, would you offer what fair market value was before this became an issue? Well, the answer again is probably not. But the issue goes even further than that. Think about appraisals. An appraiser is going to have to factor this in to their evaluation of the property, which means that a buyer would have to put up a higher loan to value ratio in purchasing the property. And frankly, a bank would probably need a higher ratio even above and beyond whatever the appraiser figured out. So ultimately, you're looking at it being really challenging for buyers to finance these homes. And that's if banks even choose to put new loans on these homes. Now, as of right now, no bank has stepped forward and made an official statement on this. I think they just haven't been put in that position yet. When we look at conversations with private lenders and stuff like that, most of them are saying that they would likely renew loans on these properties, but they wouldn't really want to put new loans on. Again, a new purchaser is going to need a new loan. The banks are going to be really careful about this because they do not want this to turn into bad publicity. So more than likely, they'll help people renew mortgages on existing ownership, and they'll just kind of carry it through and kick the can down the road until we get somewhere further else. But the reality remains, the people who own these homes likely are at least 2 years from being in a position where a buyer would consider bringing them an offer or a bank would consider lending on it. And so they're stuck for the time being. What lies ahead is likely some kind of negotiation between Canada and the Aboriginal tribes that claim Aboriginal title on these lands. And in that negotiation, we'd hope that they would cede the land back to Canada so we could carry forward with what we've been doing with title for over a century, for centuries now. And in exchange, they'd get some form of reparations in exchange for their claim to the land historically. And I think I speak for all of us when I say that I hope that we can reach something that makes both sides feel whole. Ultimately, though, the cost is going to be significant and it needs to come from somewhere. Most people don't believe that private landowners will be put in a position where they're expected to make any form of reparation in order to clear their title. It would most likely come from Canada, but ultimately, that's still something that comes out of Canadian taxpayers' pockets. So it's going to affect us. And in addition to that, the scope of what these claims could grow to look like in between now and when we ultimately reach some form of arrangement is kind of scary to think about, because it could take years, and that's a lot of runway for more people to build dissension between these two groups. So we hope that we can find a way to resolve this quickly, but in the interim, it's something that everybody is watching closely. Unfortunately, at this time, we don't have answers. So if you have questions, I'd encourage you to go down the dark, deep hole of the internet and see what you can find out and share in the comments, because I'd love to hear what's popped up in your research. I'd also just like to honor the fact that people historically have been on these lands for so long, and I truly do hope that we can find some way to honor that in a way that makes them feel whole and allows Canadian citizens to continue enjoying the private ownership of land that we've had access to for such a long time already. Ultimately, if you have plans involving anything where I can be of assistance, I'd love to connect with you. So you always have the option to grab some of my time using the link in the description. And if this was interesting to you, please like and subscribe, because it's something that I'm sure I'll be doing a follow-up on soon. Thanks for watching, and we'll catch you on the next one.